last video on the Fair Business Practices Act, I touched on the consumer notice requirements. This O.C.G.A. Official Code of Georgia Annotated, Section 10.1.399, which requires the consumer to send a notice of demand to the dealer, and we're going to use dealer as an example here, but the consumer to send a notice to the dealer alerting them of what the violation is and making a specific demand to remedy that violation. Then I talked about the other entity that can pursue an FBPA claim, the state, through the Secretary of State and the Office of Consumer Protection. If that happens, the way that usually starts, the way the dealer finds out usually, is through a notice of investigation or an investigative demand. The Secretary of State's investigative demand comes by certified mail usually, or some sort of trackable notice. I've even heard of it served or hand delivered before, but usually certified mail. And it will include in that demand a notice that an investigation has begun of a violation of the Fair Business Practices Act, and it will include a subpoena for records that the Secretary of State is asking for the dealer to produce a certain amount of records, maybe all deal files over the last 6 months, or the following 10 customer files. It could be anything. It depends on what they're investigating. And it will usually also include a date for the dealer to sit for a deposition where they will literally be interviewed by the Secretary of State regarding these allegations. It doesn't always state the specific allegations, and it will not state who made them. That is almost always kept confidential forever. So the dealer is not going to find out through the Secretary of State who actually made the allegations. But that shows up, and that's usually the beginning of a fairly lengthy process that my advice is that every dealer gets counsel if they're being investigated by the Office of Consumer Protection. When I say get counsel, I mean get an attorney, because these are lengthy proceedings. There's a lot of heavy legal review and negotiation and analysis that goes into these things, and no dealer should just go in blind to a Secretary of State investigation. But that's how they usually come, through a notice of investigative demand with a list of documents they're requesting, and oftentimes information requests as well that open up the investigation.